Okay, it's about 7:01 p.m. and today is February 1st, 2022, and welcome to week number five, five, okay, of Contemporary Issues in Criminal Justice. My name is Richard Wright, and I'll be with you roughly for the next hour or so, close to that. And I'll be talking about the assignments coming up for this week. Okay, so let's share my screen. And there it is. So let's start out with the calendar. As you can tell from the calendar, I like the month view. This is where we are. We are no longer in January. Today, the initial post is due, the live lecture. Then we have week 6 lecture will take place on Thursday at 7 o'clock p.m. And the reason being is because the week 6 lecture would take place the 8th, but that's the last day of class. And then the reply post is due on Saturday for Module 5, the assignment, and then the live classroom phrase will be due. The last day of class is the 8th. As you see, it does not go to the 9th, 10th, or 11th. So it's important for you to get your assignments in. Okay. Let's go to the announcements. So there's the week 5 announcement, which we're going to deal with criminal procedure, one of my favorite weeks. The other is the dealing with the communication, written and oral communication. And we're going to deal with activities, the purpose of law, foundations of criminal procedure, steps in the criminal justice process. And of course, the lecture is now going on at 7 o'clock p.m. Discussion assignment that's due tonight is DNA submissions. And reply posts, of course, are due Saturday, as I said. Your written assignment, warrantless searches, is due Sunday. And then your key phrase. And then you know about my motto, adversity is the springboard to success. Okay. I noticed that you guys have fallen off coming to the lectures. I don't know why, but that's something that you do. Okay, it's very important, though, that you be involved in these last lectures. So we're going to first look at the written assignment for this week. And we deal with the Fourth Amendment, of course. That's the basis under the Constitution for where this all falls into place. And read the following scenarios based on lecture notes in this module, the things that I'll be talking about in this module, whether you as an officer would be permitted to conduct a warrantless search. So you're going to look at scenario number 1, number 2, and number 3. All right. So what you're going to do is you're going to prepare a 2 to 3 page paper. Now, here is where some of you don't do well, and I know you know better, is that APA is the standard for all these written assignments. I've said this over and over, and you know your paper should be in APA format with in-text citations throughout the paper, a cover sheet, and a separate reference page. Okay, you may want to refer to the lectures in the module here about dealing with that. And I always talk about this. I've talked about this since day one. It's a Word document. It should be not single space. It should be double space. So I want it double space. Remember, if you're having APA problems, which I doubt if you don't, because you guys are familiar with this by now. Okay, so uh, it's going to be double spaced, and make sure you separate. I would put a caption for scenario number 1. Then I would write. Don't write me one long paragraph either. And if you cite a case, good people, you know my policy, and that I want you to cite the case using the official court case. And generally, the cases that you will cite will be United States Supreme Court cases. So you want to make sure you cite them accordingly. Don't cite Oyez and don't cite fine law or any others. Cite the official court case. Very, very, very important. Here's the rubric, and here's what happens to you. If you don't have citations in the body, look what it says. No reasons in support of the position. In order to provide support for your position, you must cite cases. You must cite sources. In each scenario, you could end up over here. You can write some very good information, but you can't be over here. So you have in scenario 1, offering reasons, but when your reasons are given, you must, not you shouldn't, you must have credible sources referred to as citations in the body, appropriately APA presented, official court cases appropriately presented. And you will see throughout the lecture tonight when we run across that to remind you for each of these 3 scenarios. Very, very, very important. I've had a few of you that have some good papers, but you ended up over here because you didn't have any support. Now, your reasons are not strong enough unless you have credible sources, citations in the body, and references at the end. So you don't want to lose half the points and end up over here and your grade ends up around 55. Very, very clear. Remember, I operate in this column, mastery. Okay. And it is due, as I said, on Sunday. Double spaced, said it one last time. Then your discussion post, which is due tonight, and you're going to look at this fact pattern and read it over. And then you're going to review the 2 sources below. Then, at least in a 250 words, give your opinion as to whether you think collecting DNA samples prior to conviction is violating the 4th Amendment search and seizure. Be sure to provide references. And then your reply post, explain why a different opinion exists. Remember, references make your opinions credible. That's what I've been saying in your written assignments. I'm not that dogmatic here, but in this case, it's a good idea to go ahead and do that if you do. All right, now, here's the PDF that you should be able to download. I'm gonna double check it to make sure that it works, and I'm pretty sure this one does. Here it is. Yep. And this is where you can find there's some court cases. Now, this court case here in Maryland versus King is a leading case that involves this. All right. And then talks about other states, jurisdictions, and so forth. Now, give statutes and so forth. Explains state by state when things are connected. I would try to consider my own state. Now, I want to show you something. Let's see, I thought it was in here, but it's probably up here. Let's click on this. Yeah, there we go. So this is the Supreme Court website. Should be able to find opinions. Oh, okay, opinions of the court. This is U.S. reports. And you can find the source. You can also find it in other forms in our library system. I thought they had it in here. It's not in the assignment itself. Let's see. I know I saw it in here in something. Okay, I think it's in here. I think it's in the footnotes. Let's see. Uh, they didn't do this. Okay. Okay, here's what I will do. This is what I'm going to do. I'm going to pull it out. That's what I'm going to do because they should have it in there, but they don't. Okay. I'm going to tell you the Maryland versus King citation for the United States Supreme Court is 569 US 435, and the year was 2013. Okay, that is the appropriate citation for it. Okay, so Maryland versus King, the appropriate citation is 569 US 435, and it was in 2013. You can find it in library resources. I don't like the fact that they don't put it in. Well, this is the way that they put it in here. But I would have appreciated it if they had put it in the assignment itself. Okay. All right. So it's a very important decision there when it comes to dealing with that issue. All right. And it's the leading case. All right. Let's leave the discussion. And then let's go down here to the purpose of law. So why do we have law? Why do we have law? Law is another word for law, as I ask my students oftentimes, and it very simply boils down to rules. Rules. It's based on case law. It's based on statutes. It's based on the case laws, court cases. It's based on the United States Constitution as the principal source. So when we refer to the amendments, the Fourth Amendment, the Fifth Amendment, the Sixth Amendment, the Eighth Amendment, which are pretty much the ones that we use in criminal justice. The Fourth Amendment involves search and seizure. The Fifth Amendment involves not testifying against yourself, not being forced to make statements, or to utilize confessions, interrogations, leading case, Miranda versus Arizona. Okay, and then the Eighth Amendment has to do with bail and also the time that you are penalized. That it should not, you should have reasonable bail, and that the crime should be commensurate. That the sentence should be commensurate with the crime. Okay. All right. So we have all of these different components. The four, law enforcement, which deals with the investigative bodies. You have the adjudicative aspects of it, which is the courts, the corrections for probation, and then you have the appeals section. So if you, of course, win in the trial court, you don't go to probation and you don't go to the appellate. And you know that corrections consists of four things. If you remember from introduction to corrections: jails, prisons, probation, parole. That's it. Okay. But we maintain order with the law. Okay. The Constitution, as I said, set the basis for it. Fourth Amendment says again, protects us against unreasonable searches and seizures. In other words, before a search can take place, you must have two things. First of all, one, probable cause, and two, must be a warrant signed by a judge. But we're going to talk about some exceptions which also exist. And the key thing here is to protect the privacy of individuals. Okay, but probable cause is the basis for most searches, except what we call the Terry stop, which is the short time stop, as some people, the pat down search. And that stop does not require a warrant, and it does not require probable cause. It only requires reasonable suspicion. But remember, the purpose for the search is that it is for the protection of the officer investigating to see if the individual has any weapons, and if in the process of checking for weapons they discover contraband, then they can arrest that person. Then that's when probable cause comes about and you're arrested. Now, keep in mind that when those type of things happen again, it's going to have to fall under an exception. That's not right. I want to fix that because that's not right. They typed this wrong. It's warrant. I didn't do that, but now it's fixed. Okay, so exceptions to the warrant requirements. So the course developers left that error in there. So here we are with the exceptions. One exception is consent. And what that means is very simply what it means. You agree to let the officer search you, and that it has to be voluntary, absolutely voluntary. And the question which I want to ask, and since we have Jennifer here, I'm going to ask you, if you come to me and you ask me, can you search me? And I say yes. At this point, is it consensual? Yes or no? Okay. On the same scenario, but let's add some stuff. It's you, and you got 6 police officers, and I'm surrounded. And you ask me, do you consent to a search? Would that search be consensual? Yes or no? Right. And what changes the scenario is that you are not evidently free to go. And look what it says. Um, they give circumstances where it must be voluntary. So if that person is surrounded like that, then they probably are under pressure. Consent is valid if the third person has equal authority over the residents. And conclude the absent person assumed the risk of the roommate might permit a search. So the roommate could permit a search of the residence. Let's say, though, for example, if the roommate consents to a search, is it a valid search if they have, of course, separate bedrooms? Can the roommate give authority to search the roommate's room? Exactly. Exactly. And the consent, it said, must be given by both people if they're present, but if the other one is not. Now, here's one. I tell my kids this all the time. I read them their Miranda warnings, but then I say this: parents have the right to consent to search a child's living area if the parents have routine access to the area and the child is not paying rent. So I got a 21-year-old son who he will be 22 very soon, and his room is just a few feet around me. And we go into his room and we go in there and we find something. And he says, "Oh, you violated my privacy." He's out of luck because he doesn't pay rent. He doesn't pay rent at all. But if he's paying rent, even if the door is not locked, then we would be violating it. Landlord, because we'd be the landlords in that case, cannot give consent to search if a lease or rental agreement is valid. Those kinds of things. All right. So the consent, as it says, to summarize this part argument, is that it must be voluntary and written permission or consent to conduct the search. Uh, what was that you said? I, I saw you said I am glad my son is not up here listening to this. He will never clean his. That's too funny. How old is he? How old is your son? 20. Okay, yeah. Yeah. Yeah, they think they're grown then because they past 18. I says, I don't care. You living in my house. Get your own house. Get your own place. Eat your own, don't, hey, what you got to eat over there? No, you don't live here anymore. Okay. But yeah, so I hear you. That's kind of funny, but I agree with you. Exigent circumstances. What is exigent? It means that in a situation where if there is some delay, uh, it could result in evidence or a suspect getting away or harm uh, to someone, one or the other. And the court often looks at, was the offense a violent offense? Was the suspect armed or not? Was the probable cause strong enough to believe that that person actually committed the crime? Was there strong probable cause to believe the person was on the premises? Did the police identify themselves and give the suspect a chance to surrender prior to entry? And was there an ongoing investigation and decision or decision to arrest prior to fleeing, the suspect fleeing? And then finally, it exists if the police are responding to a domestic violence call. Um, when I was a police officer, we were always told, be very careful with domestic violence calls. They are the most violent calls that you could ever have. Uh, you're familiar with what happened in New York, right? Are you familiar with what happened to these two officers in New York who answered a domestic violence call? Yeah. Both officers were killed. Two of them were killed. I have been in situations where we've gone in and the female has called us and we go in and we start to grab the guy and she says, "That's my man. Don't hurt him." And she's bleeding and, you know, black eyes and furniture's turned over and everything's torn up and stuff. Um, Crazy. I actually witnessed that in my own house, as you know my story about what I grew up with. My mother, when the police came to get this guy at the house, she was, no, no, I love him. You saw the movie What's Love Got to Do with It? You ever see that movie with Ike and Tina Turner? The Tina Turner story? Yeah. So that kind of stuff. There's nothing to gist and joke about domestic violence. That's how I lost my dad. That's how I lost my mom. And so I totally get it. And so police know that that's an exigent situation. And you have to be very, very, very aware watching the other side. Open view. It means what it says. That's one thing about the law. Open view. It means that where the officer is from their uh, vantage point, or that the public could view, such as in a parked car, for example. If an officer is putting a parking ticket and notices a bomb inside the car, he may go inside the vehicle, or she, without a warrant. Um, you look in the car and you notice um, red substances uh, in the car, which could be blood. You can check inside the car in those kind of situations there. The key thing and the bottom line is that you could see those kinds of things. Plain view, kind of close to open view, but if an officer is conducting a lawful traffic stop with probable cause, or in a home where you entered the home lawfully for a lawful reason and sees contraband inside the vehicle, you may seize that contraband or that. Do you remember in the trying to remember which was it, criminal law? Um, it might have been another course, but I think it was, and I think you might have been in that class, um, where the police officer was allowed to come in and ask. It was a discussion assignment, asked to go to the washroom, and um, and that they stopped on the way and looked in the refrigerator, and there was a head in the refrigerator. Do you remember us talking about that? Were you in my class, in one of my classes, when we covered that? Do you remember that? Yeah. Well, what happened is I remember the police officer uh, arrested him, and then they charged him, but the case was thrown out because uh, they had no business going in the man's refrigerator. And let's say, and I think I posed a scenario that what if it had a glass window? Then you could see inside the refrigerator without, it's like one of those refrigerators you see in a store or, display type. Then you walk by and you see it. Then in that case, it would be considered in plain view. But just like you're going to the washroom and then you uh, go in somebody's medicine cabinet and you just went in there to use the washroom, that's not plain view. Plain view means it must be able to be seen. You come into my house and you walk in and you it's like I'll give you an example. This is too funny. I went to visit some, and this wasn't a criminal issue, but you'll get the point. I went to visit some members of the church, not the church I pastor, but I was an associate minister at a church, and I was sent to talk to the couple and the families. And so when I got there, um, I uh, took a seat, and when I looked down by my feet, I saw um, a bottle of alcohol, and they said, "Oh, how'd that get there?" I laughed, and I said, "If I told them if I was the police and that was contraband, you would be under arrest because somebody left it out." But they were embarrassed because I said, I just kind of said it like this, Jennifer. I said, "Well, that's okay. You don't have to hide it from me. God saw you drinking it before I got here and after I leave here." And he kind of chuckled and said, "Got me on that one, Reverend." So anyway, that you get the point when I say plain view there. Pat down frisk, that's the old Terry stop. Remember, the purpose is to discover weapons or items that would pose a danger to the officer, and it's limited to the outer clothing or a coat or jacket or pair of pants, those kinds of things. Can you go into the duffel bag that that person has uh, in a situation like that? Yes or no? Nope, you sure don't, because that violates it. And so, but if you have a situation that includes, this is but not limited to, prior knowledge that the suspect carries a concealed weapon, just different suspicious behavior, um, such as failure to comply with the instructions uh, to keep hands in sight and things like that, uh, putting their hands in their pocket, those kind of things, big bulges, consistent with concealed weapons. So if you pat down somebody and you feel uh, like they might have a plastic bag and in their pocket, and they're not they say, can you go in the pocket then? Probably not. If you do, you might have a problem. Prior knowledge that the suspect is a verified member of a gang and carries weapons. Remember the key thing of the Terry stop, Terry versus Ohio, was to for weapons, not contraband. Okay. Search incident to an arrest. So let's say if you somebody's under arrest and then you can search their general area where they are in control of and the area within the arrestee's immediate control. Okay, you're under arrest, sir, and you place handcuffs on them. Can you search the areas close to where they're standing? Yes or no? You said you said now you can go into the pockets or socks. Are you asking me that? You talking about this search incident to an arrest, or are we talking about the pat down again? Which one are we talking about? The search incident to an arrest, the one we're on now? So if you're talking about that, uh, can you go into the pockets if they're handcuffed? So is this an area in which the arrestee's immediate control? Possibly, possibly. Such as you were arrested in the home or something like that. They're close by. But you can't go into another room, right? If you go into another room, you messed up. Am I right or wrong? I think your answer is yes. Search engine to the arrest. Yeah, okay, yeah. The answer is yes. Okay, correct. All right, so now the last one is custodial search. So officers thoroughly search the persons who are taken into custody, and the search conducted as reasonable or as soon as possible after the arrest and before moving the person. Evidence of any crime which is discovered in a valid custodial search whenever subsequent charge is appropriate. Now that might be where what you were talking about a few minutes ago. Then you go through the pockets and stuff like that. So because the person is in custody, then you will stand probably a better um, chance of having some contraband or whatever you discover from that stop to be used. Okay. All right. So the general rule that you need to understand and just be aware of is um, have a warrant. If you don't have a warrant, make sure that you're very careful and follow the parameters. And you must have, and by the way, there's some more exceptions, but we didn't cover those, like attenuation. We had a couple others, but those are not, those are, some of them is a little complicated. So, all right, here's my favorite thing. I love this. I used to do this very well. And I was kind of like this fella here, except back in those days I had more hair. I had a fro. I did. I had an afro, and I didn't have a beard, and I had a mustache, but I didn't have like a big fro, a bozo fro. I had a nice neat one. So 12 in the box. That's what my mentor used to tell me. The late Judge R. Eugene Pincham, who was a powerful criminal defense lawyer, who suggested that I get involved with the National Association of Criminal Defense Lawyers and that I attend a seminar that took place in '84 July out at the University of San Diego, which we spent a week and we were lawyers in trial advocacy in the public defender's office, and a bunch of us flew out together and hung out. Well, that was where the section I was assigned to, and we had these mock trial things. And the guy who was my instructor was a guy named John Cochran. That was his name. You ever heard that name before? You heard that name before? John Cochran? Yeah, but you heard it's Johnny. Yeah, OJ. Yeah, OJ. And for those of you who are not here, she's not talking about orange juice. They used to call him the juice, but his name was Orenthal. That was the old suit for. And uh, the J wasn't for juice, but that's what we called him. I think it was Jerome. But at any rate, yeah, Johnny was his lawyer. And I learned from him in 80. It was funny in 84. Now I didn't associate, of course, 10 years later, I would turn on the TV and I was reporting on the O.J. Simpson case for three radio stations in Chicago here, and they paid me handsomely. I remember I got paid $500 a week for a year. To It was 1, 2, 3. I think it was 4 days a week that let's see, no, it was $300 a day for each station. So that was 900, and um, I got really paid pretty well for that. Remember, put me in another tax bracket for that year. But I used to record it and then talk about it. But it was Johnny who was his lawyer, and then Johnny would later on come to Chicago even after the case is over. And Johnny and I sat down and talked, and we reacquainted when I reminded him of the 84 encounter with him. But he used to tell me, he says, along with Judge R. Eugene Pencham, said, there's no other way to go. You do a jury in most cases. And so you at the 12. Notice what he's doing. He's doing exactly what I used to do. I used to do hand gestures. I used to get up and talk to them. And look at them. Look at them. Everybody's focused on him. That's what I used to do. And I used to win over 90% of my jury trials. I sure did. Because I could communicate and also lay out the evidence. I didn't misrepresent it. I never would do that. I refuse to do that because I'm a firm believer that integrity has to be maintained there. Somebody, how could you be uh, operating under integrity and represent a criminal? I says, first of all, number one, they're not criminals until they're found guilty. All right. Even if they've been, well, they might have been if they had a previous case. So I guess you might have a technical point there, but on the case that I'm representing them. So you get the point. And so we dealt with the statutes in the jurisdiction that we were in, and the what we call the three elements of crime. Actus reus. It means what it says in Latin. It's the act. The act. Um, then uh, that is. Then you deal with the intent. Mens rea. Did you see Legally Blonde? Did you see that movie? Yeah. In Legally Blonde, remember Elle Woods was giving the judge a lecture in mens rea. And the judge says, I know what mens rea is. Counselor, could you get into the facts of your case? It's too funny. But it means the state of the act of mind. And the two of these come together to determine whether or not the individual could possibly be accused. Did you hear me say the word accused? Not necessarily have committed, or that's the argument, the pretext to bring the charges. And it makes it easier uh, for them to bring the charges against individuals. And so we deal with the elements of the process, starting with the arrest itself and going through the steps from the arrest. You will then be brought up for a bail hearing. And then if you make bail or don't make bail, then a preliminary hearing will be set up, or the grand jury could indict you, and you are then charged by what we call information. And that's the grand jury. It votes on what we call a true bill, where the grand jury, by the way, is a place I never was allowed as a defense lawyer. Defense lawyers are not allowed at the grand juries. And so the individual's case then comes before the judge, and then you are if they found probable cause to take the case full blown, then you'll have an arraignment hearing. And at the arraignment hearing, there's only two things that you should be doing at the arraignment hearing, one or the other. If you saw My Cousin Vinny, did you see that movie? Okay, you remember Joe Pesci was before the judge. Uh, Fred Gwynn, the former Herman Munster, and the last movie that Fred did before he died, where he was the judge, and Vinny um, was going into the facts of the case, and the judge says, "Mr. Gambino," because that was his name. He says, "There's only two things I want to hear from you, one or the other, guilty or not guilty." And he frustrated, he had to say not guilty. If you say guilty, then you go right to a plea. But if you say not guilty, then you go to the steps of moving forward. And then when you move forward, then and I'm just giving you the steps, right, throwing them at you, how they pretty much work in practice, is that then there is a phase called discovery or disclosure, which once again, if you saw My Cousin Vinny, he learned that he had the right to the evidence that the prosecution had, and he could question the witnesses. But all jurisdictions have that, and that allows the defense a chance to get the specifics of the charges, not just the charges, but the evidence that is in the prosecution's hand that they note. The prosecution cannot legally withhold what we call exculpatory evidence that they're aware of. That is evidence that might be damaging to their trial, their case, but could exonerate the individual, those kinds of things. And so applying the statutes, so if we find out that when we get evidence that the statements were coerced or the evidence was received in violation of the Fourth Amendment search and seizure, um, or they violated the Sixth Amendment when they did it, then we would file what we call a motion to suppress as lawyers. And we would go through the process of seeking to have that information not be allowed to be used during the trial. And we also have other motions. We could move for a venue change if we think that the person couldn't get a fair trial in that venue because of pretrial publicity or something else. Or we can also move to have our client examined by a psychiatrist um, to determine their fitness to stand trial, or whether they were fit at the time of the trial, which is very unsuccessful in most cases. I never had one that came back that said they were not fit to stand trial, or that they were not excluded because of their mental state, a John Hinckley type or something like that. You may recall the Oakland, Michigan shooting at the high school that happened I think it was last month. But at any rate, um, now there is a motion on the floor that the attorneys are filing to examine their client for their mental state. It's a process you go through anyway. It, you know, they should, the parents should be examined as well, because you know what they said. if you follow the case, it was pretty egregious. So, and then you have a right to have, and then if we go back and we look at some of the things, you have a right to have an attorney doing questioning. Um, that's the Sixth Amendment. You shouldn't have excessive bail set against you, and you have a right to a speedy trial. Now, the Speedy Trial Act can operate very funny. There are periods when the defense attorney or the prosecution and defense attorney by agreement decide to stop the clock from running. So if you have 120 days or 4 months to bring the individual to trial, that time may start and stop. And believe me, the defense attorney and the prosecution have a little thing that we call a speedy trial chart, and we would mark off so we know how many more days we had. And if you get past that speedy trial chart, then the defense attorney has an easy job, and they file a motion to dismiss. Okay, the exclusionary rule allows statements that are obtained, Miranda warnings, not given property, search and seizure, those kind of things. Okay. The Supreme Court said in the infamous Gideon versus Wainwright, the right to have an attorney present as well. You know, I really don't like the fact that they don't put the whole decision in there, but you know, I like the full decision. Okay, yeah, fast case. Fast case, you can find that information. Okay, now this was the lower court case here, but if you go up to the Supreme Court, okay, like for example, here's a case that was involved in that, the Betts case, and notice 316 U.S. 455. Now that's the official court decision. And then this is a West Law edition. And this is what we call lawyers cooperative. These are all, but the official one is when it says US in there. Okay. And then that was a 1941, which was the year of that case. But you can find things like that. But I'll just tell you that, you know, fast case, if most paralegals know about fast case, and you can find cases utilizing that. But the key thing is it's so easy. The one thing you can do, and I tell you, you could Google, if you did Google Gideon versus Wainwright, it will lead you to the exact court citation. So if you use it in your papers, make sure you do that. The final thing is the rules of evidence govern the admissibility of the evidence, and all procedural guidelines are in written form. And now we've got evidence that comes in using technology, of course, you know, cameras, video stuff, as was the Derek Chauvin case, many other cases these days. The case that took place down in Georgia, Ahmaud Arbery, where the police officer, the 3 men were found guilty of murdering Ahmaud Arbery, police officer Derek Chauvin, and now these other officers are in federal court for that in Minnesota. Fingerprint information analysis. We have experts that come in and testify and all those different things. And this is utilized to deal with the process so that individual is guaranteed a fair trial. If you're found guilty, of course, then you generally have 30 days in which to appeal, and appellate defense attorney is then usually appointed if you can't afford one. And you go into the appellate process, and depending upon whether there are any issues that violate the Constitution or not, the federal case can go all the way to the top court of the land, which is in the news now, the United States Supreme Court, where the 9 justices listen and determine and issue a ruling. And those are the top rulings that we usually ask you to use when you're doing your research. So that's the foundations of criminal procedure. I already told you this, so we don't even really have to spend much time. We went over this already, from arrest to preliminary hearing, grand jury, indictment, entering a plea, um, evidence that's presented, direct evidence, circumstantial evidence. Real evidence consists of physical evidence. And in the course of trials, you'll see one of these. Circumstantial is a whole lot of times brought in, where the judge or jury draws conclusions based upon the information. And then you get your opening arguments and closing arguments. And then there's what we call the jury is charged and given the opportunity to learn with the law, and then they deliberate. Jurors must be unanimous, and all 12 have to agree. If they cannot, then they could become what we call a hung jury. And so if it's my daughter, they put her on a jury trial in Cook County, and I don't know how she got on, because they asked the jurors questions about, their family members and what they do and all of that. So I had a little bit of everything in there, being a policeman, investigator, paralegal, defense lawyer, for the biggest part. And so, and then also, uh, they asked, they found out her name, well, she was married. And so they couldn't ask her, uh, her maiden name. I think that was one of the things that was allowed. But if they were, they would have found out her last name was Wright, and they'd have said, "Is your dad Richard Wright?" you know, we're dismissing you for cause because you know too much. Oh God! But anyway, as it was, what I was going to tell you is that she was anyway somehow miraculously got on the jury, and she was the youngest one on the jury, but she was appointed the foreperson, and she hung the jury. She's she was stubborn. That's like her dad. She was stubborn. She refused, and she's not a lawyer today. She works as a clinical psychologist, so she didn't want to go to law school, but she probably would have been good. But at any rate, she hung the jury, and the judge had to tell them that. And so, guess what? On retrial with a different jury, what do you think the results were? Guilty or not guilty? That's exactly what happened. And the judge who knew me real well, he says, "Counselor, see, your daughter missed her calling." Yeah, Illinois. Jennifer, I think are you in Illinois, Jennifer? I think, aren't you in Illinois? Yeah, so you know Markham, right? You know Markham, Illinois? You're on the north side, right? Mid. Okay, so um, what's the name of that town? Arlington Heights, up there near Arlington Heights. What's the name of that town that court is in? Up by the oh, you're further. Oh, you're in Rockford. That's right, aren't you? You're in Rockford, right? In Rockford area. Yeah, I forgot. Yeah, I remember. Not. It just came back to me. Yeah, you're right there. That's not even part of Illinois. I got a lot of friends out there though, in Rockford, but that's where you got too many Packer people out there. Yeah, it's a cool city. I say that just in joking, but one of my dear friends lived there until he passed. But I used to love to come to the campus. Um, you went to the campus. you could go to do your banking and then go to class, right? Because you're in the Chase Bank building if you had a Chase Bank account. Oh God, yeah. So it's the campuses. You said you had not you have not been able to, or you have not really? You never been to the campus? You know where it is on State, right? Yeah, okay. And you do know it's in the Chase Bank building. It's in that building. It's I forget which floors. Two floors they have in there in that building. So one day they're talking about they're going to get their own building right down the street from the clock tower. You know the clock tower, right? Yeah, yeah. COVID locked all the campuses down. So definitely. All right. So anyway, that's it for this week, and I'm gonna give you the pleasure, since you're here, to tell me what do you think a good uh, phrase, key phrase would be. Oh, the clock tower is leveled? Oh no. Oh God. I always think of the clock when I see the clock tower. That was my landmark. That's why I knew where to get off at. And but oh wow, they took it down. Uh, the Hard Rock Casino. Oh, got to be some gambling there. Huh? Okay. Um, okay, that's it. You got it. Criminal procedure. Jennifer called it. So if you don't get it right, blame Jennifer. Okay. It's her fault. All right. But no, that's a good one because that fits appropriately what we covered pretty much tonight. So, well, this is not the last time this week you'll see me. If you come back Thursday at 7 o'clock, that will be for the grand finale, and I'll save my parting words for Thursday night. So, but yeah, wow, about the talking about the clock tower again. Um, as you may or may not know, if you look at my story enough, or may have heard me mention that the writer, creator, director of Back to the Future, Robert Zemeckis, was my high school classmate and graduated with me. Did you know that? Yeah, yeah. Bob graduated from Fanger High School, which is where I went on the way south side of Chicago. And Bob sat alphabetically behind me because alphabetically that's how we sat in class back in those days, um, before technology and all that stuff. But I was W and he was Z. Excuse me. And we used to talk, and he said he was going to be a movie director. I said I was going to be a lawyer. We both made it. Yeah, but Bob, the reason why I mentioned the clock tower is that it's in Pullman. It's the Pullman clock that was at 111th, right near Cottage Grove, and it's still there. That's where it came from. But whenever I'd come to Rockford, I'd always think about that as well. So yeah, but Bob did a bunch of movies. He brought cartooning to the movies in Who Framed Roger Rabbit. And then he did, um, let's see, he also did Last Holiday with Queen Latifah. Did you ever see that one? You saw that movie, Last Holiday? It's funny. You got to check it out. It is hilarious. Um, but he did Forrest Gump. You saw that one, right? And Forrest Gump was a character that was in his head forever. And yeah, he got an Oscar for that one. Yeah. But yeah, we lost contact. We just had our 50th class reunion a couple of years ago, and he wasn't able to make it because he's still mad at some of the people in school who didn't. They ridiculed him. They called him a what they call him. Uh, he was a geek, like a geek. Anyway, I was called a geek too, also because I wanted to become a lawyer or something. But they teased us both, but we both kind of remembered. So I mean, when I do go to California, I know how to hook up with him and get in touch with him. So. All right, I'm going to say good night, 8:06 p.m. But yeah, Bob is, he's, people who have had contact with him told me that he's still the same um, Robert Zemeckis, who was, I'm trying to remember what was that term they called us. It wasn't a geek. It was what would they call us? Nerd. Yeah, that's what it was. Thank you. You saw the Revenge of the Nerds then, right? One of my favorite movies. But yeah, they called us nerds. He was the white nerd, I was the black nerd. But yeah, but I used to carry a briefcase around. Yeah, well, as we say, you'll work for us. I'm a lawyer. I've had many people employed to work for me. You got to go through me. As a matter of fact, I have a lot of people who become criminal justice professionals. They came through this nerd. Oh God, but it's cool. And then the girls, oh, you're one of the nerds, or you're one of the ones that came through me. Both. Okay, that's okay. It's like I went to Northwestern. We always tell people we didn't have the best sports team when I was in school. We say, but that's okay. You'll work for us. We had people like Jerry Springer. Did you know he went to law school at Northwestern and that he was a lawyer? Yeah, his first gig was mayor of Cincinnati, but then he departed from that. Jerry Reinsdorf, you know who that is? You know who Jerry Reinsdorf? You're a Cub fan, right? Yeah, that's why you don't know. He's one of the owners of the Sox. You're a Bulls fan? You like the Bulls? They kind of making noise, but the Bulls, well, I haven't been a real Bulls fan since Michael, who I knew personally, but yeah, Reinsdorf owns that too. He owns those two teams, so he graduated. You know. Oh, oh, really? Was your cousin was a Lovable? Oh, okay. Well, I might have known her then because I knew the Lovables. I knew a bunch of them. I dated two honey bears. You ever heard of honey bears? Emily F. Peterson. Name rings a bell. Rings a bell. Kathy Core was their royal leader back in those days. I don't think Kathy is the leader anymore, but she led them back in those days. Um, do you remember the honey bears? Oh, they were the Chicago Bear cheerleaders. We actually did have cheerleaders on the sidelines, and they used to wear those little skimpy outfits, and it would be so cold. But they did. But yeah, I dated two of them. It was back in my youthful, crazy days. So what was I thinking? Not thinking. Anyway. All right. Thanks for hanging out with me, Jennifer, and I'll hopefully see you on Thursday for the final. Uh, Yeah, they work hard for them and they don't pay them much. I think they paid enough to get their uniforms cleaned, and it was they weren't in another tax bracket, that's for sure. But they used to make a lot of money on personal appearances because they would go to events and then they would make money then, so. All right, I will see you guys on Thursday. And again, stay safe. I'm not going to repeat what the key phrase was because Jennifer and I have been just chit chatting. I gave it earlier and you should be able to get it. All right. Stay safe. Take care of yourself. Stay warm out there. Hey, you guys getting snow out there too? No snow for you. We are. You want us to send you some? We can't. You know why? Because you're west of us. Snow generally doesn't go east to west. It goes from west to east. And the northern part of the state will catch it, but I think it's coming down from the great state of Wisconsin. But anyway, that's another discussion. See ya. Take care.